just like the judge said, these are closing arguments. And remember, in opening statements, the state talked about what the evidence would show. We didn't go into a lot of great detail about what the evidence would show because, frankly, there hadn't been anything presented yet. So this is the state's opportunity and the defense's opportunity to run through exactly what all we've seen this week. Now, folks, I'm human, just like every single one of you. And so before we go into the law and the evidence, I just want to say that I sat in that chair or questioned witnesses, and I perceived facts as I heard them. But if there's anything that I say that maybe you recall differently or don't remember hearing, please know that I'm just human and I'm not trying to mislead anybody. And most importantly, rely upon your own recollection of how you saw the evidence this week. Okay? All right. And so just like we talked about in the opening statement, the facts that we're here to deal with are sexual assault. Happened on December 5th, 2019, here in Guernsey County. And that was when the defendant raped and kidnapped M.M. Rape and kidnapping. Those are the charges that we're here for. In the opening statement, we talked a lot about that law because it's important. It's important to know the exact law and how it applies to the exact evidence that you all have gotten to hear about throughout the entirety of this week. Rape. Here, we've got jury instructions. You're going to get these two. And this is what you're going to see in the jury instructions. I think it's on page 5. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 5th day of December in Guernsey County, Ohio, the defendant engaged in sexual conduct with another, and the defendant purposely compelled the other person to submit by force or threat of force. So that's kind of what you're going to read here. But like we talked about in the opening, within the law, we break things down into elements. So what it really turns into is these 4 elements. Has the state proven those, every single one of them, beyond a reasonable doubt? And the state would submit that it has. We've got to show that there was sexual conduct, in this case fellatio, with M.M. Certainly she's involved, you've heard her testimony. And that there was a purposely compelling somebody to submit, and by force or threat of force. And that's really what this falls on. But before we get into that, we've got some definitions, and again, these are going to be in those instructions. You all, triers of fact, Judge Padden determines the law. He will instruct you on these things. Fellatio, the practice of obtaining sexual satisfaction by oral stimulation of the penis. Pretty straightforward. Just what it sounds like. Really not up for debate in this case. However, force. Another very vital, important instruction. Any violence, compulsion, or constraint physically exerted by any means upon a person or thing. And that's critical. And that can be interpreted a lot of different ways, just like we talked about in open. It doesn't necessarily have to be physically grabbing somebody. It can be an environment that's created. It can be a dynamic. But it can be physically grabbing somebody. And there is evidence of that. Now let's look at count 2, kidnapping. Some crossover with it, which makes it easier. Again, your jury instruction is going to read similar to this at the top. The defendant did, by force, threat, or deception, remove M.M. from the place where she was found, or restrain the liberty of her for the purpose of committing a felony or flight thereafter. So this is an important point. Removed from the place where she was found, or restrained her liberty. And that's clarified by these elements similarly. And the state's proven every single one of these elements beyond a reasonable doubt. We've got that same force, threat, or deception language that we had for rape. We've got that M.M. was removed from the place where she was, or her liberty was restrained. And folks, you're all going to have a copy of this as well. this is something that you can refer to and should refer to, because these details are critical. And I'm sure you've all realized that what can seem straightforward often gets very, very detailed. Being a juror is really difficult. And that's why we selected you. So we knew you could be objective, hear these details, and garner these facts. And that brings us back to these allegations. Now, the way this plays out, as the judge said, the state gets its opportunity to do an opening or a closing argument. The defense gets a chance, if it wants to speak to you all in its closing argument. And then after that, we get a chance to speak. And so what I want to do, since this is our first real interaction since Tuesday, is run through every single witness that was called and really highlight some key parts of their testimony. You recall on Tuesday we called Deputy Fair, the Guernsey County Sheriff's Office. He's a deputy. What's his role? He's not a detective. We were able to clarify that. He's really the first law enforcement officer from Guernsey County Sheriff's Office involved in this case. And he shows up, and what does he do? He does what any good first responder does. Creates a preliminary report. Report, that's a weird word. In their opening statement, the defense mentioned there were no reports. The very first witness we hear from has a report. Does that make a lot of sense? Do those arguments make sense? No. Because it's not accurate. Deputy Fair testified. He was able to see MM at the hospital. Was trying to just take some introductory photographs. But it's important to remember, he's not the lead on this case. Deputy Fair isn't calling the shots. He's just trying to gather initial information so that he can do the right thing and work it up his chain of command. Get it assigned to an appropriate person who can handle an investigation of this level. He's also able to pick up the evidence the next day and work on getting that transferred to BCI. And that's where we hear from our BCI personnel who examine it. It all ties together chronologically. The next witness we heard from, Brianna Woods, the first civilian we hear from in this case. Now, when I'm walking through these, I may mix up statements by Brianna or Brooke or MM or run through them because I think we can all agree, everyone here, these were young kids who were out drinking at bars. They're 20, 21 years old. It's not all that uncommon. Brianna talks about the day really started at Applebee's in Zanesville. Maybe there was some shopping, maybe there wasn't some shopping, but they were in Zanesville, they had a lunch. They go back to Brianna's house and decide they're going to go out for the night. Now, again, another common theme in this is it's steak night at Wagner. Everyone knows about steak night. So, Brianna recalls her and MM going to steak night, having some glasses of wine, eating dinner. Brianna's got some friends there who she works with, or I think the regulars there and she works there. Justin Ayers, Austin Smith. They meet up with them, things are going fine. It's a pretty normal night. It's probably a fun night for 20 or 21 years old. They make the decision they're going to go to another bar. They go to RJ's. And it's at RJ's when the defendant first makes his appearance, we'll say. Now, Brianna isn't exactly sure how those communications go between the defendant and MM, but it's pretty clear there were some Snapchat messages sent back and forth. And that's fine. That's not a big deal. And things are fine at RJ's too. Remember, Brianna talks about what RJ's is like. It's a bar that serves food, but really it's just a bar. It's got pool tables. They're playing pool, having a pretty good time. Still drinking. Brianna recalls MM drinking about the same pace as she does, and they're starting to get buzzed. Fine. They ultimately end up in Callis at Star Bar. Now, Brianna's recollection is a little bit unclear, kind of where Brooke is in all this leading into it. Now, mind you, this is 3.5 years ago. And that all these witnesses testified, but just testified to the best of their knowledge from something that happened that long ago. So there's going to be some inconsistencies with recollection. There are going to be some issues with memory. Ladies and gentlemen, do you remember things from 3.5 years ago in great detail when it comes to bar hopping? No, it doesn't make sense. It makes sense that you might not know some stuff or remember some details. And you know what? Nobody got raped at Wagner. Nobody got raped at RJ's. Nobody got raped at Star. That's not the scene of the crime. So the state would submit what inconsistencies are important and what are of less importance. Every inconsistency is important, but what weight do we give that? And that's critical. Brianna, and I apologize, continue drinking at Star Bar. The defendant is there. The friends are still there. I think at this point, Damon Carpenter has come around. So there's a crew of people, again, still having a good time. The defendant offers to buy some shots, fire. and Brianna take the shots. They go out to the parking lot. They have a conversation with the defendant. And the defendant wants them to flash them because he bought them shots. The best judgment? No. Probably not the best judgment. But that's not the scene of the crime. This case was about the defendant wanting to take control. And that's what he did. And that's really when that control starts. That's when the opportunity to offer a ride comes forward. When the Star Bar is closed. Brianna acknowledges that she's been drinking a lot. It's been a long time. She gets into the truck. Damon Carpenter's with them. The defendant's driving. MM is in the front. And again, trust your own recollection, but the state recalls MM may have been in the middle of the truck. And it's not a bucket seat, it's a bench seat. I messed that up in my testimony. It's a bench seat. So, they drop Damon Carpenter off, and it's just the two girls and the defendant. Brianna gets in the front seat. Again, relatively intoxicated at this point, understandably, given how their day was. And is either awoken or recognizes MM trying to get her attention. And why is she trying to get her attention? Because the defendant is grabbing her leg. And they laugh about it. Maybe the term is giggle a little bit. Now, on paper, that reads strange. In hindsight, one would think, oh my God, that's not okay. Why is he acting that way? But use your common experience. Put yourself in that perspective and how you act. It's been pretty clear the defendant didn't have some history of being a bad guy. He was at least an acquaintance of these people. Sure, it's strange, but what are you going to do in that moment? You didn't get a ride from a stranger. It's not an Uber driver. In that moment, doesn't just laughing about it kind of make sense? Doesn't addressing an uncomfortable situation in that way kind of make sense? Isn't that something that people would do? The state would submit that it is. And then Brianna talks about kind of being in and out of sleep, going to exit the vehicle once they get to the house, and MM saying, I'll be in a minute. So I just went through a large background, the largest chunk of Brianna's testimony. And the rape still hasn't occurred. That stuff's important, no doubt about it. But is it the most important part of this case? Is it the critical part of this case? No. It shows the beginning of that control. Then when Brianna exits the car, she leaves. It puts MM alone in the truck with the defendant. That's what's important. That's what corroborates. That's the vital part of Breonna's testimony. She ultimately goes in and goes to sleep, is informed later about what happened, and makes a statement to the police. She came in, testified to the best of her ability and truthfully. The next witness we heard from, M.M. The only witness we heard from who was there. Who was there when this happened. Detective Coulter said it best. Her body is the scene of the crime, not some truck. M.M. recalls the day similarly, but with some inconsistencies. And it's worth noting, were they big, major, important ones, or are they ones that make sense? They went to Zanesville. She recalls Brooke being there. They go to Wagon Wheel. M.M. recalls drinking some, maybe not as much as Breonna were to say that she were drinking. But she's not saying she wasn't drinking at all. She acknowledges Snapchat conversations with the defendant, acknowledges being out with them, acknowledges going to RJ's with them. And you know why? Because nothing's happening then. That's not when the rape's happening. Those things are fine. It's okay to meet up with the defendant at the bar. It's okay to meet with Josh Sills there. It's okay to potentially think about getting with somebody. It's okay to take a shot of Fireball. While it might not be the best judgment, it's okay to flash somebody. What of those things is an invitation to rape somebody? The state would submit that none of those things are. You can drink as much as you want, and that doesn't create the opportunity to be sexually assaulted. That doesn't give somebody the right to be able to do that to you. M.M. gets in the truck with the defendant, sits in the middle console at some point. I believe her recollection is that she's sitting in the passenger seat and moves when Breonna Blitz moves up. You can sit as close as you want to somebody, and that doesn't give them the right to rape you. Right? Common sense. M.M. talks about when they get to the house. Breonna gets out of the car. M.M. acknowledges that she says, "I'll be back in a minute." M.M. talks about being pulled back in. Being back in a minute is not an invitation or giving somebody the right to be raped. It doesn't give somebody the right to rape you. M.M. is able to talk about what actually happens in the truck. She gives details. Now, folks, I gotta say, rape's messy. Sexual assault is messy. I'm guessing you all are realizing that. Recollections aren't always the clearest. Does it make sense, though, that when something's happening like that, you might not be in the clearest state of mind? Especially if you've had some drinks. You might not be trying to notate exactly how many times you were strangled or the exact timeline of how these things went or exactly where you were when you were held down and pinned down. Does it make sense that that might be something that could be a little fuzzy or could be difficult to recall in great detail? Talks about being grabbed by the back of her head in her ponytail and forced to perform oral sex or fellatio on the defendant. She was not free to leave. The moment this scuffle started, her liberty was restrained. But let's pause. Wasn't there some consensual kissing that happened? Didn't we talk about that? Didn't she bring that up? Yeah. Didn't she not mention that originally? Yeah. Well, I guess the point still stands. Does consensual kissing give somebody an opportunity to rape you? Is that what the law says? Was there any element that I pointed to in the law that the judge is going to instruct you on that says, well, if you can prove that the victim started consensually kissing somebody, then it's okay to force fellatio? Find it in jury instructions. If you find it, follow it. You can say no and not consent to something at any time. You know what does make a lot of sense, though? Somebody who's been sexually frustrated makes a claim that they have blue balls and isn't going to let somebody go and is going to take control of the situation physically. And is going to start by grabbing somebody by their leg, starting that physical nature of this. And when they see somebody coming up the driveway, getting on top of somebody and muffling them, the defendant was going to do whatever he could do to get what he wanted. And he did. And once he got it, what did he do? Made sure that he was going to take control of the situation. Has a conversation with MM. You're going to talk to me again, right? This is going to be fine, right? You're never going to talk to me again, are you? You're going to talk to me, right? Folks, draw inferences from statements like that. Those are statements that people make when they're trying to control a situation, when they're trying to control a dynamic. MM acknowledges it. Put yourself in her shoes. She's been through a horrifically tragic incident. Do you think she's thinking about, okay, how many times have I been strangled? That was pretty hard. Then there was the other one. I think he got the back of my neck. Are those the kind of things that somebody who's been raped is thinking about? Somebody who's been through a traumatic event? Is that the kind of detail they're looking for? No. MM just wanted to get out. She was going to do whatever she could to get out of it. And she did. Now, there's a funny part of this case. It's 2023. This happened in 2019. You might be wondering, what's the delay here? What was the holdup? Why is it taking so long? Folks, MM immediately reported this. There was no gap in time. Nothing. And anything you hear contrary to that is incorrect. What did MM do the second that she got out of that truck? She went directly into the house and told her friends exactly what happened. Now, are her details different from then versus now? Sure. But there was no gap. This was reported immediately because it happened. Does MM wait a little bit before going to a hospital? Sure. Again, put yourself in the shoes of somebody who's just been through that. Use your perspective. Think of a traumatic experience that you may have been in. Does it make sense that there might be some processing time when you've been manhandled and raped? Does it make sense that you aren't thinking about a court case in a situation like this and how it might be perceived or how you might be questioned about it? Why you waited? It doesn't make sense. You're not thinking about those things. You're thinking about what just happened to me And how am I going to tell somebody about this? By the big name football guy. Who's going to believe me? Against the defendant, the college football player. Who's going to be on board with that? And in that same light, there have been some questions about a stepsister who dated the defendant, how that might impact why she would fabricate or make this out to be something that isn't. Folks have heard about it. Doesn't make any sense. Think about it. If I were to engage in some kind of consensual activity with my stepsister's ex-boyfriend or whatever he was at the time, if they were back together, whatever it was, couldn't I just not tell anybody? Who was going to know? Was there anybody else in the car when this happened? Josh didn't even live here. If MM wanted to keep this a secret, she could have. Her sister never would have found out. There's not going to be a Snapchat video showing that. There's not going to be cell phone evidence showing that. Because it doesn't make sense. Don't let red flags and red herrings distract you. What makes sense? Another thing about MM. She was on her period when this happened. It's notated in the medical records. She tells the defendant. So she's just trying to get with and hook up with this guy when she's on her period? Sure, you could do that, right? We all know that. But does that make a lot of sense? Does that add up either? Common sense, folks, that's what we're here for. Some inconsistencies when you recall something are okay. Consider them. Remember what really happened here. And what makes sense. MM goes in, has a rape kit completed on her. Not pleasant, pretty intrusive, not pleasurable. Has a victim advocate there. Why is that a big deal? In what world does that make a difference? Who cares if the victim advocate's related to a law enforcement officer? Does that really matter here? Or is that just something to distract you from what really happened? Who cares? Think about it if you want, but is that really important? Who cares if the victim's or MM's mom is a nurse at the hospital? Are you supposed to believe that because MM's mom's a nurse, that they would push this to go forward? In what world does that make any sense? Guernsey County is not a large area. It's not an urban area necessarily. Do you think this is all that uncommon? That witnesses on a case might know each other professionally or as acquaintances? Is that surprising? No. Happens all the time.
10 minutes remain, counsel.
Thank you, Your Honor. Look at indications for any kind of inappropriateness. Does it make sense who called the hospital to report this? Again, consider everything that was talked about, but give it priority, folks. Okay? We heard from Leslie Durfler the same. She's able to take examinations, photographs, take a history about what happened, notate injuries. And folks, unless your name's Dr. Howren, there are injuries. Now, the degree of them have been argued about throughout the case, but there are no doubt injuries in this case. You see them on the back of her leg, you see them on her face, you see parts of the TPI and congestion, all noted by Nurse Durfler. Defense counsel accused her of cutting corners and not doing certain things. What's the number one thing that Leslie Durfler is concerned about? Patient care. A medical expert should not be worrying about how a case is going to present in court or how she's going to be attacked. We're trying to do the best job she can. Their focus and their top priority is patient care. So sure, are there some things that could be brought up on that? Yeah, that's fine. But her concern is patient care. She notes those injuries and details them for you. You're going to have a report showing that. And remember what she said about sexual assault cases and strangulation? 50% of sexual assault cases don't have any injury at all. Oftentimes, strangulation shows no injury at all. It's very common in sexual assault cases for jurors to think, there's got to be an injury, I got to see something, I got to see more. Folks, you can have it with no injury. Brooke Bean testifies, talks about what his demeanor was like when she came in the house, and just how upset she was. Does that make sense? Does that disclosure make sense? Yeah, because it happened. The way she's talking about it happened. I've only got a few minutes left, but let's talk briefly about Detective Coulter and his investigation. He interviewed these witnesses. There was a point where he was accused or asked about coaching witnesses. Now, folks, there's an important thing to note here. When somebody asks a question on the stand, it puts a thought in your head. Were you coaching? Our own biases tell us, oh, coaching, what is that? What did Detective Coulter say? No. And that's what we're to consider. Not the idea that might be put in your head by a question. You are to consider the evidence, the answers. What's set up there? Could Detective Coulter have talked to some of those male witnesses? Yeah, sure. Were they in the truck when MM was raped? No. Would it be nice to know what they said or saw? Sure. But folks, the state doesn't have to prove this case beyond all doubt. Just reasonable doubt. And one witness, if believed by you, again, this is going to be in your jury instructions. One witness, if believed by you, is sufficient to prove any fact. If you believe MM, that can be it, folks. By itself, that can be enough. But that's not all we have, right? We've got photographs. We've got testimony. We've got DNA from Devaney Herman, all linking this, all showing that this happened, backing this up. In my last couple minutes, let's talk about what the defense put on. They put on a doctor who didn't say that his main priority in medical care was treating patients. Would you go to that doctor? Would you go see Dr. Howard if you were injured? When he's worried about creating a case? That's the equivalent concern to an injury? That makes no sense. The guy backtracked on everything that he said in his report. Because he knew it was wrong. And he knew it wasn't backed by science, it was junk. Now, Dr. McCullough makes some good points. I'll concede that. She's much more polished. But she makes concessions of her own. Mr. Walton talked about that. Notes that an MRI doesn't always show injuries with respect to strangulation. Acknowledges that with strangulation, there can be no injuries. That's a defense expert, folks. Acknowledging the exact same things that we've been talking about. You don't need injuries to be sexually assaulted. You don't need injuries to be strangled. You don't have to be strangled to be sexually assaulted. That's not in the code. So it's important to know about those things. It helps put the story together and explain what happened to MM. But it's not required. And so, folks, when you consider the testimony that you've seen, collectively speak about this. Look at the photos, look at the physical evidence, and you use common sense, you should find that the state's met every burden of both of these charges beyond a reasonable doubt and find the defendant guilty of both charges. Thank you.